Right, some more paper. I hope there would be. I think to be fair to you, it is what we asked for. Namely, the front pages of those, which is helpful to have. Thank you. Of those. Right, we have now had the opportunity to read the Smythe's note. I mean, there are three heads. The first two I really don't think require any further elaboration or any response. The third, Ms. Smythe may be right that it merely restates her position, but in any event, it is a hook for us really just to raise a point which we just wanted some clarification on following particularly Ms. Ward's submissions yesterday. Ms. Ward emphasised that the reasoning in AT depends on Article 21 conferring residents' rights. Under, I forget the exact phrase, under or perhaps on the basis of Article 21, and those are substantive rights, whereas Ms. Smythe's approach was to say that although Article 21 was a necessary part of the court's reasoning to get to the Charter, it didn't depend on it having conferred any substantive residents' rights. I may be critical of Green, but that's really the point of difference between the two. And we would welcome just a short clarification from Ms. Smythe as to exactly why she submits her analysis of how Article 21 is relevant in AT is preferable to Ms. Ward's. That may lead to some debate, but if you can do that for us now, Ms. Smythe, we will. Not sure Ms. Ward is strictly speaking entitled to a right of reply. We may or may not ask her for one, but clearly I think Mr. Cox will be entitled to one.
My lord, yes, I'm grateful. So the court has the 5 points, and I understand at least from Ms. Ward that she is satisfied that those 5 points were made yesterday. So dealing with the IMA, and I'm grateful to the court to the opportunity, because as the court will understand, this is an important issue to those instructing me. The position is as follows. The IMA says that she has a right of residence.
Just give me 1 moment, sorry, I just... Yes, sorry, yeah.
So the IMA says that the appellant has a right of residence because of AT. And the first thing I want to say about that is that this is a label problem, because it doesn't help to say it's a residence right without explaining what that means. And we know from reading the case law that this right has been called various things, including an umbrella right, an anchoring right, and a triggering right. So I'll deal with it expressly at the moment, because I just developed this point about the label problem. Our submission is you can't use that label without explaining what you get from it. Now, our case is that whatever label you give it, the legal effect that it has, and the only legal effect that it has, is that it triggers application of the Charter.
Well, the only legal effect it had for the purposes of AT was that.
Yes. Yes, so I'll come on to could it have any broader effect, but could I just remind the court in terms of the legal effect, first of all, that AT is a case about CG. So AT does not purport to go further than CG.
No.
And if it did, it would be overture. So to understand AT and Lord Justice Green's reasoning, which, as I said, approves the upper tribunal, it's necessary to look back at CG. And I took the court to various passages where, and I'm happy to repeat what they were, but I said them yesterday. Yes.
I've run out of highlighting on some of them. No new colours, nothing. I mean,
Yes.
we've been over them a lot. So
Yes,
it's useful
exactly.
to
So
have.
I'm not proposing to repeat them, but the point I would make is that I showed the court various passages that when the ECJ talks about right of residence, it talks about a domestic right of residence. It expressly says she has a domestic right of residence. Now, albeit that triggers application of the Charter, nowhere does the ECJ and CG say that there is an Article 21 right of residence. So can I make that point first of all, that's what CG says.
You just pause while I reread the relevant key bit of CG.
Yes, of course.
You're on 82 around there, are you?
It's 87 to 89, this is a particular page.
And then
So 88, where the member state grants a right, they implement the provisions of the treaty.
yes, so it's all about implementation because that's what the court is dealing with. Does the Charter apply? It's not does she have a right of residence under Article 21, it's is the UK, when it grants this domestic right of residence, implementing the Charter for the purposes of all of the case law about when the Charter is triggered. So although it, and that's why Lord Justice Green also refers to it as an anchoring or triggering right, nowhere
Well, implementing the treaty, yes.
Yes, nowhere does the ECJ say, and she has a right of residence under Article 21. I will deal with it on that basis that it is a right of residence in a moment, but I just to emphasise in CG, so the paragraph I mentioned when it refers to a domestic right of residence, I know why I can't find it because it's in the EU law section of my submissions. Paragraph 89, 93 and 95 all refer to a domestic right of residence.
Yes.
So nothing in CG, and I'm trying not to repeat what I said yesterday, but I probably need to deal with the point. What I said yesterday was nowhere does the court in CG say that she has a right of residence under Article 21. What it says several times is she's been granted a right of residence.
Well, I dare say, but that's because that was the position on the facts of that case. But we're on a slightly different point, aren't we? Or maybe we're not. That there clearly is such a thing as a right of residence under Article 21.
There is.
So why does it matter that that was not how it was expressed in CG, which was about a domestic right of residence?
Yes, but because what's being said here is there's a right of residence which satisfies the conditions of Article 23(1, residing on the basis of the directive. So that's why, coming back to my later problem, if one says, oh, well, there's a right of residence under Article 21, well, the question is, well, okay, let's say CG or AT had a right of residence. What does that actually give her? So supposing that CG turns up, or AT, the UK says, well, you've got a domestic right of residence, but we've changed our mind. We're going to, we're not going to do that anymore, it's expired. If it's being suggested that at that point, because of the analysis in CG, she can say, well, I've got a right of residence under Article 21. You can't. I just don't have. I don't have to comply.
Well, is
with
the,
any
okay, but
conditions.
is this the point, or is this a different point? You accepted early in your submissions, and you just have again now. Clearly, there are things called rights of residence under Article 21. Article 13 refers to them, and an example you gave, or perhaps it was Mr. Cox gave it first, is to share rights. They're all basically rights recognised in the case law of the court. Article 13 treats as different, or at any rate as enumerates separately, rights under the directive. And is this a way of looking at it? Article 21 creates a freedom of movement right, which in certain circumstances, defined by the court, to share being an example, is, as it were, self-standing, doesn't need any subsequent legislation. But where there is subsequent legislation, then Article 21 has no independent operation. It is the Article 21 right is the right granted by the directive and has no other content, and will come with the conditions granted by the directive.
Yes, but people can, I mean, the case at tab 12, which has been alternately referred to as JD and Crayfeld, shows that a person can have a right to reside even if they're outside and not meeting the conditions of the directive. But they get that from another bit of legislation.
Yeah, well, quite, yes, sorry.
But it's back to, if one forgets about secondary legislation and just looks at Article 21, we come back to my point that there is and never has been a free-floating, here I am, I'm turning up to France, either without or with my Colombian husband, but I'm turning up to France and I'm not going to comply with any conditions at all, and I am going to positively assert against France that I have a right of residence. I just can't do it. There's never been the ability to do that. If I want to rely directly on Article 21, I would need to show, and this is what the case law, which carves rights, if you like, out of Article 21, what it does is do that against the backdrop of the imperatives of free movement. So the reason that the Surinder Singh right came into being is to protect somebody's right to move to a state. So it has conditionality built into it. So when Article 21 says, subject to the limitations and conditions laid down in the treaties, those include the fact that there is no general right, never has been, to go and live in another member state. It has to be within one of the pillars or complying with the conditions in secondary legislation, effectively. Yes. So to say, it's radical to say now, post CG and AT, there's actually a different Article 21 right of residence, which is unconditional.
So can I take you to the upper tribunal in AT?
Yes, of course.
Where Mr. Justice Chamberlain thinks that CG establishes that through the UK granting a more favourable right of residence, the UK was implementing Article 21, that's paragraph 93, and then in 102 he refers, as Ms. Ward pointed out, to AT retaining that part of her bundle of Article 21 rights which entitles her to continue to reside in the UK.
Yes, but that has to be read in the context of the rest of it, which is, yes, but for the purposes of a right of residence, subject to limitations and conditions. So one has to read that with Mr. Justice Chamberlain's reasoning of 106, which is the part that the Court of Appeal adopted. What he says, and we pick up on it in those 5 summary points, the best encapsulation of it and the simplest in my submission is that what he's not saying there's a positive right of residence. What he's saying is you can't apply the limitations and conditions in Article 21 if it would breach somebody's charter rights. So he starts from the premise that yes, Article 13 does carry over the Article 21 right, but he makes clear that that's the same right it always was, which is a right which comes with limitations and conditions. You can't say otherwise because we've looked at the wording of the treaty, that's what it says. So he starts on that premise and he says so in terms, and I showed the court passages yesterday, but what you can't do is insist on those limitations and conditions if to do so would breach somebody's charter right. So it's not so much that you've got a positive right to reside
so
without conditions.
It's a defensive position.
It is, yeah, it's backstop.
So just starting at the beginning then, if you have an Article 21 right, that might be the thing that takes you to another member state because you want to exercise your right of free movement. So that's what takes you abroad. And then you do on day one have an Article 6 CRD right,
do,
don't you? So
yes.
you do then have a right of residence.
Exactly.
But notionally you lose that or it dissipates or something at the end of your 3 months. So then you have nothing under the CRD. What happens to the thing that was your Article 21 right that took you there in the first place? It's just a nothing, is it? It's part of the history of why you got there in the first place, in your case.
History of what got you
So
there in the first place.
it's factually connected with your
Yes.
presence in that
Yeah,
member
it's how
state.
you got there.
It's how you, it's
exactly.
part of the explanation, but in terms of legal rights, you never did. You'd say you never had a right to reside there. You had a right to go there to exercise free movement in a sort of general abstract sense. Does that, I mean, is that
Yes.
roughly speaking?
I was just going to say, and that's partly why Lord Justice Green described it as an umbrella
Yeah.
right, because it continues,
It's a
if you're
different
under
sort
the
of right,
umbrella,
yeah.
it's continuing, which is one of the other names he gave it, another label that I didn't mention, but it continues to generate legal effects. But the legal effects don't include that you can say to the member state, well, you can't remove me, I've now got a positive right of residence under Article 21.
Can I just before we just follow one other thing through that? I think I have stumbled a little bit on what limitations and conditions means in the context of Article 21. So, what do the draftspeople of Article 21 mean by limitations and conditions? Do they mean you'll have to look somewhere else to find out what the specifics are of your ability to stay here? So typically you'll look at the CRD, but there might be other regulations knocking around in different circumstances that might help you. Is that what
They
it's
do
saying?
mean that, but they also mean inherent in the treaties, or the wording, again I have to keep looking at it, but the wording is the subject to the limitations and conditions laid down in the treaty. So in other words, if you take the whole body of EU law, in what circumstances, if there isn't a right in secondary legislation, which there isn't for the Surinder Singh right, to take an example, when the court develops that principle, it does so by reference to general principles emanating from the treaty. So it will say something like, if there isn't a right in this situation, it will interfere with the right of free movement, referring, for example, to the right to work or the right to go to another state. What it doesn't do, and what has never happened, is to just say, and in fact the case law says over and over again, there is no unconditional
There's
right
no
to reside.
freestanding right.
There isn't. So you have to look whether when the court carves out a right from outside secondary legislation, it's still very much principle based and includes conditionality, which is part of the right. So the main point I'm making is wherever else we end up, nothing in CG and nothing in AT is authority for the proposition that there is now an unconditional right of residence under Article 21. And I said, and I stand by the point, if the Court of Appeal had decided that in AT, in circumstances where that was not the issue before it, it would have been overturned, and it also would have been wrong.
But you said it's heresy. I mean, it's badly wrong.
Well,
isn't it?
it is, because and one has to look back at what one has to look back at. Well, one has to look back at all the cases and see how it works. But if and one has to one can't just take, oh well look here, Lord Justice Green referred to a right of residence, so that must be what he's saying. One has to look at all the different ways that he describes the thing. That's not helpful.
It's not helpful, Mr. Cox. It's not helpful.
One has to look at everything he says. He says umbrella right, he says anchoring right, he says triggering right. So, and to the extent that he says it's a right of residence, you'd have to then say to Lord Justice Green, well, we've got this other case here. Mr. Cox is saying it also means that I should get social assistance under Article 23(1). Is that what you meant, Lord Justice Green? He would have to say, well, no, I wasn't deciding that point. So it doesn't help, just because Lord Justice Green used the words, and it isn't funny, it doesn't help that Lord Justice Green used the words right of residence to say, and aha, that binds this court and it forces the Secretary of State to accept that there is a right of residence, which means there is now residence on the basis of the Withdrawal Agreement for the purposes of Article 13. He may, I mean, perhaps if we'd been looking at the corrections more carefully, we could have said, well, hold on, that might have broader consequences, or perhaps we did, I can't remember. I mean, certainly it was a concern, but the point is, if that's taken out of context and without then an explanation from Lord Justice Green that by saying that he meant X, Y, Z, then that's a dangerous interpretation of the judgment. But if that is to be the interpretation put on it, then I will go so far as to say it is obiter and it is wrong, because it goes further than CG and it isn't what needed to be decided in OT. So
I
that,
think you did
that
make
is the
that point.
position. I don't shy from that label, but I just say it's just a label, yes, but what do you mean? What do you mean by it? And the answer is, does it get in this case, and can I just finish the points I was then going to make in relation to the MA? The answer in this case is, okay, let's call it a right of residence, let's call it that. Does it get you social assistance? Does it qualify for Article 23(1) purposes? And the INA say no, and the Secretary of State say no. I say
But
no.
why? I mean, but the crude answer would be, once you do call it a right of residence, it is clearly a right of residence, therefore, under on the basis of this agreement. How do you construe your way out of what would appear to be the clear language of Article 23?
Because that is simply a label. Because the other thing that Lord Justice Green has said and approved is Mr. Justice Chamberlain's formulation, which is not. It's that you're basically stopped from applying limitations and conditions. That when Lord Justice Green first deals with this point, he cites the upper tribunal. Now, it's right to say in the Court of Appeal it all got very complicated, partly because of some of the arguments we were running, but fundamentally, what is the Court of Appeal's conclusion on this point? It's approving 106, which is to say you can't, you can't basically, you're stopped from applying limitations and conditions. So
Well, I don't want to, well, I do want to stop you, otherwise I wouldn't be. I sort of got, I think we've got that point, and it's true we got into this because of AT, which is a difficult case, and the other. But just suppose AT had never happened. What is the answer to the question I put to you? Once you accept that Article 21 grants a right of residence within the meaning of Article 13(1), how do you get out of what appears to be the clear provision of 23(1) that in those circumstances are entitled to equal treatment?
Well, it's the answer in these 5 bullet points, because Article 23(1) says residing on the basis of the withdrawal agreement, and Article 13(1) says that, I'm going to quote it precisely. Article 13(1) says, not that you have the right to reside as set out in Article 21, it says you have the right to reside in the host state under the limitations and conditions as set out in Article 21. So to suggest that even in a charter case, let's take a charter case where those limits, when you're stopped from applying those limitations and conditions, and I can back this up by reference to CG. Let's take a charter case where you're stopped from applying the limitations and conditions. Yes, the government can't apply the limitations and conditions, but you're not then residing on the basis of the withdrawal agreement, because you're not complying with the limitations and conditions.
But what are the limitations and conditions, as my lady said, set out in Article 21?
Well, let's start with CG. We'll start with CG. Remember in CG that the court did 2 things. The court in CG said, 1, you don't get the equal treatment right because you're not residing on the basis of the directive. 2, as analysed by the Upper Tribunal and Court of Appeal in AT, it said, second, member state, you're stopped from insisting on application of the conditions. If it were the case that in a case where the member state was basically stopped from assisting on the conditions, you can benefit from equal treatment, the first issue in CG would have been decided differently.
Yeah, we saw, you said, made all those points yesterday, but
so what are the limitations and conditions? In CG, because it was a directive case, it is the limitations and conditions in the directive.
yes,
In a withdrawal agreement case, it is the limitations and conditions set out in the withdrawal agreement, and they are such rights as are carried over from EU law that are carved out of Article 21 direct from the treaty, and they are the directive rights and the Regulation 492 rights to which specific effect is given. So what otherwise we're basically crossing out the words under limitations and conditions laid out. It doesn't make sense to say, even in a case where AT bites, well, you can't apply the limitations and conditions to me, and so therefore I'm residing in accordance with them. But bear in mind that in this case we're not even in that territory. There's no charter assertion that we can't apply the limitations and conditions against this appellant.
Yeah, well, we're not really talking about, I don't find it helpful to talk about the charter. This isn't a charter case.
But it does go to the question of what are we left with Article 13.1 in my submission, because essentially what we say is, it's there in the 5 points.
Okay,
Can
now
I just-
we'll promise to reread the 5 points. Or...
But effectively, you can't apply the conditions to a person who's within scope of the withdrawal agreement and who holds pre-settled status that would reach their rights. However, that's not this case. Therefore, the limitations and conditions continue to apply. What are they? They're either inherent in the treaty right, see the case law for that right, or they're in the secondary legislation. Given that the limitations and conditions apply to the appellant, then it must be right, if she's not complying with them, that she's not residing on the basis of the agreement.
And by not complying with them is what you mean that she can't find herself place under Article, she can't find a treaty right under Article 21.
Yes.
She's obviously not under the CRD.
Yes.
And there's nothing else to help
Exactly.
her. So she's left
Exactly.
empty-handed. I mean, is that
That's it.
might be a bit humdrum, but is that
No,
what it
no,
comes
it's
to
not
on your
humdrum.
case?
It's excellent. But that's it.
But no,
It's essentially, look, Article 13 is telling you, and Mr. Justice Chamberlain says this, as does the Court of Appeal when it repeats his conclusion. Article 13 brings in Article 21 with the fact that there are limitations and conditions inherent in Article 21. So it really is, my point D and E, there are limitations and conditions that apply to this appellant. Article 13.1 tells you that there are. But given that she's not complying with them, she's not residing on the basis of the withdrawal agreement.
Maybe that's just again just to get your case right, but just to understand where you're going from. That limitations and conditions is perhaps you might be able to rephrase it as saying, to the extent that there's any content in Article 21 which might avail her, that's transported into the withdrawal agreement. But it's looking for the content of the substance that might be there that might avail her. And I think your argument is there isn't anything like that.
No. What she says is, well, my right of residence comes from CG and AT, but that's circular because CG.
You say you don't get there.
You don't get there, and I don't, I'm afraid, simply because at one point the Justice Greens used the phrase right of residence, one has to say, well, okay, tell us then what is that? What are the conditions on it? When does it work? When does it allow somebody to say to the member state, you can't remove me, I'm staying here, which is after all what a right of residence is. And one has to not take bits and pieces out of context, but look at the whole analysis. And as I submitted, bear in mind that it's about fundamentally just the analysis in CG. So where we are, could the court just indulge me for a moment to say where we are? The IMA and the Secretary of State agree that whatever you get from CG and AT, it's not good enough for the purposes of Article 23.1, and I set out why I say that is. Now, if there is a broader question between charter on the one hand and social assistance on the other, then that is a hypothetical question in this case, and it should be decided if and where it arises. That may be, I think, the difference between the IMA and the Secretary of State. It's about something that isn't an issue in this case. Because if I can I'm doing hands to make it clear, but one end we've got charter, you get charter rights. The other end we've got Mr. Cox's case, which is that you get full-blown social assistance. IMA and Secretary of State say charter correct, social assistance wrong. There may be situations in the middle where what really is this Article 21 right referred to in CG, but they don't arise here.
Say, if you go to Miss Ward's skeleton, paragraph 52, and she said this orally too. she says that the IMA's position is that to benefit from Article 23, you have to be residing on the basis of Article 13 and meeting the conditions in the CRD. And yesterday, I think she said, as far as the IMA is concerned, the appellant is residing on the basis of Article 13, and you don't accept that. The judgment has to grapple with that, doesn't it? It can't be left over to some future occasion.
No, and absolutely, on that point, my position, I don't know what Miss Ward's position is, but my position is crystal clear, which is D and E of paragraph 9 of this note. Article 13 says you have to be complying with limitations and conditions. She isn't. And I thought that's it in a nutshell. Now, there we are. I think that's our position. And can I just wrap it up by saying that it, in our submission, is extraordinary. When you look at the established position under EU law, when you look at the wording of the withdrawal agreement, what Mr. Cox is saying is we've ended up in a position where simply by virtue of the grant of a domestic right of residence, not only have we given access to social assistance on equal terms, but there's no basis upon which we can justify doing that.
Well,
So
we are indulging you because that really is the point you made very much yesterday. However, perhaps you're entitled to some indulgence.
So that's, unless the court, that's really our position on where we are in CG and AT, and there is a concern, I think, that there is a concern on the part of the government that AT is about a specific point.
Well, I think
Yes,
we understand the concern, and really, although it's grown, and I don't blame you, but we were really concerned with a particular point about your analysis of AT as compared with Ms. Ward's. Ms. Ward's we understood. I'm not going to call on her again. She doesn't get a right to reply. But we just hadn't really understood. We hadn't bottomed out, which we've now done, I think, with your assistance.
Yes.
How you put it as against her.
Yes.
And I think that's what this has been useful for. And
Yes.
as I said, that's why I'm not going to crawl on Ms. Ward, but I am going to crawl on Mr. Cox because he is, after all, a claimant, and you shouldn't have the last word. But it may be, please, Mr. Cox, you won't, I'm sure, treat this as an attempt to reply on some of the more general points that Ms. Smythe took in the run-up, just on the specific issue that we asked her to address us on.
Yes, and I first of all apologise to Smythe for my sedentary interruption, which was.
I didn't notice it.
Well, she did, and I'm sorry.
Oh,
Well, she may not notice that. The apologies.
I wasn't looking at you.
That's
Yes.
fine, don't worry, we don't need to indulge. My lords, the submissions you've just heard ignore the words of Article 21. The right is clear. Every citizen of the Union shall have the right to move and reside freely within the territory of the member states. That's it. It's not a right to benefits. It's a right to reside. So when the Court of Justice says that, and I won't take you to paragraph 87 of CG, that the United Kingdom recognise the right of a national of a member state to reside freely on its territory, conferred by Article 21(1 without relying on the conditions and limitations in respect to that right laid down by Directive 2004/38. That's what they meant. They didn't mean a right to benefits.
Well, okay, but that's a slightly different point. But
They meant
yes.
a right to reside. And when Lord Justice Green used the right to reside repeatedly in 18, and when Miss Justice Chamberlain used the right to reside, that's what they meant. And Miss Smythe's submission and my submission incoherently and illegitimately elides the immigration and the benefit stages, because she can't deal with them separately, because that would bring out the concerns that are raised from our side. Ms. Smythe says, does this mean that the person with PSS can't be removed?
Can't be.
Yes, it does.
No, I just didn't hear what you said. Can't be removed.
It can't be removed. She
Yeah.
said, does that really mean you can't be removed? Does it mean that a person with the French equivalent of PSS could insist on entering France? Yes. So long as the state has waived the limitations and conditions in Article 21, there is a waiver of the
I
limitations.
think, if I may
and
say so,
conditions.
you're replying on the case generally, which you've done already,
I'm sorry,
or not
but-
replying on the particular points that we were exploring with
Well,
Ms. Smythe.
Well, I'm grateful, but it's the first time the Secretary of State has raised the concern that the interpretation that we are putting forward means that a person can't be removed. Can't be removed while they have PSS. But the PSS can, of course, be revoked. Give you an example, I won't take you to it, but page 319 sets out the rule when PSS can be curtailed, based on, for example, false representation. So if it turned out that the applicant had committed a serious crime, not disclosed it, Secretary of State could curtail their PSS. Well, the effect of curtailing PSS, subject to rights of appeal and so on, would be that they'd cease to have the benefit of the waiver. Now, in my submission, it doesn't make any sense to say that a person has to comply with limitations and conditions that have been waived. So the answer to my learned friends, what's the label, is it's a right to reside. Why is that the label? Because it comes from Article 21. That's why Lord Justice Green called it a right to reside. It's not about implementation of the Charter, it's about implementation of the treaty. And so the gloss that is put on the passages in AT at paragraphs A and B of my learned friend's note, paragraph 9, A and B, is mistaken. That's not what those passages say, and it would be incoherent if they did, because if Miss 18 didn't have a right to reside under Article 21, she didn't have any rights under Article 21. So this is not an answer to the immigration point. It's not an answer to issue 1. And in my submission, what it does do, though, is show how incoherent the government's position is. Pleas to not change the system must be founded in the different stages of the withdrawal agreement and the law, not as a general urging of what should be the outcome. Unless there's anything else.
Thank you very much. Very well. Well, we will, of course, be reserving our judgments. Thank you very much for the large teams, some of which I know are appearing pro bono, so particular thanks to them. But clearly really the work has gone into this case at all levels, and as I say, we're grateful for that. Judgments will be circulated in draft in the usual way, subject to the usual embargo. The principles as we found in the Counsel General for Wales case, that should be circulated only to those who it needs to be circulated to for the purposes identified in that case, and any circulation to people who don't have such a need to see it may be a contempt of court. Thank you very much.